Hello and welcome to our vlog.
Hello. This is our vlog podcast live project thing.
So today we're going to be discussing some death penalty cases.
Yes.
So me and my good friend Roslyn are going to be talking about some important Supreme Court cases regarding the death penalty. And I believe Roslyn is doing the first point.
I am. So
Wait, don't forget our
sorry. So our first point is okay, so part A. Procedure regarding death penalty. Here are the appeal procedures. So, Greenlaw versus the U.S. Okay, so Petitioner Greenlaw was convicted of 7 drug and firearms charges and was sentenced to imprisonment for 442 months. In calculating the sentence, the district court made an error. Greenlaw appealed, urging inter alia the appropriate sentence for all of his convictions was 15 years. The court acknowledged that the government, while it had objected to the trials court's error at the sentencing, had elected not to seek altercation of Greenlaw's sentence on appeal. They relied on the plain error rule stated in Federal Rule of Criminal Procedure. The Court of Appeals ordered the district court to enlarge Greenlaw's sentence by 15 years, yielding a total prison term of 662 months. That's a long time. The court held that absent a government appeal or cross-appeal, the Eighth Circuit could not, on its own initiative, order an increase in Greenlaw's sentence. Without an appeal or cross-appeal by the prosecution, a federal appellate court cannot order an increase in the sentence of a defendant on its own initiative. So, that was in 2008. And, yeah, so now Lyla's going to tell you about a different one.
Yes, I am. Well, ASMR. Okay, so next, I will be discussing populations eligible for the death penalty. So I have a couple cases here that talk about cases that aren't eligible for the death penalty. The first case is Roper versus Simmons in 2005. This case requires us to address the second time in a decade and a half whether it is permissible under the 8th and 14th Amendments to the Constitution of the United States to execute a juvenile offender who was older than 15 but younger than 18 when he committed a capital crime. At the age of 17, when he was still a junior in high school, Christopher Simmons, the respondent, committed murder. About 9 months later, he had turned 18. He was tried and sentenced to death. There is little doubt that Simmons was the instigator of the crime. Before its commission, Simmons said he wanted to murder someone. In chilling, callous terms, he talked about his plan, discussing it for the most part with 2 friends, Charles Benjamin and John Tesserman, then aged 15 and 16 respectively. Simmons proposed to commit burglary and murder by breaking and entering, tying up a victim, and throwing the victim off a bridge. Simmons assured his friends they could get away with it because they were minors. They did, in fact, commit this murder, doing exactly what they said they were going to do, which I am not going to discuss because this is quite graphic. But at the end of this crazy ordeal, the Supreme Court did find that a minor cannot be sentenced to death because their brain is not fully developed yet until they're of age of brain development, which I'm pretty sure is 25. Another case that has to do with populations eligible for the death penalty is Atkins versus Virginia. This case regards Darrell Renard Atkins, who was convicted of abduction, armed robbery, and capital murder. In the penalty phase of Atkins' trial, the defense relied on one witness, a forensic psychologist, who testified that Atkins was mildly mentally disabled or mentally retarded in the vernacular of the day. The jury sentenced Atkins to death, but the Virginia Supreme Court ordered a second sentencing hearing because the trial court had used a misleading verdict form. During resentencing, the same forensic psychologist testified. This time, the state rebutted Atkins' intelligence. The jury again sentenced Atkins to death. In affirming, the Virginia Supreme Court relied on Perney versus Lyla in rejecting Atkins' contention that he could not be sentenced to death because he is mentally retarded. Is the execution of mentally retarded persons cruel and unusual punishment prohibited by the Eighth Amendment? Yes, in a 6-3 opinion delivered by Justice John Paul Stevens. So, people who are minors cannot be sentenced to death, and people who are mentally retarded cannot be sentenced to death. And, yes, that is some Supreme Court cases that have to do with that.
That was really interesting and sad, both of those. So now we're gonna turn to, this is the 2000 case of Robert Glenn Coe against Tennessee. Coe was convicted of the 1979 aggravated rape, murder, and aggravated kidnapping of an 8-year-old girl and sentenced to death. Coe's attorneys argued he was not mentally competent for execution, citing insanity, and that executing him would violate the Eighth Amendment prohibition on cruel and unusual punishment. A Shelby County criminal court judge initially ruled Coe's competency was genuinely an issue. An evidentiary hearing was held, after which the judge found Coe competent to be executed. The Tennessee Supreme Court affirmed this decision after reviewing the claims. Lower federal courts also upheld this finding. Coe's execution was the first lethal injection in Tennessee in 40 years. His attorney also argued it was illegal for medical professionals to perform a lethal injection. However, a Tennessee judge previously concluded that physician participation in executions was lawful. Coe's execution was stayed several times by federal courts to review his competency claims. Ultimately, the U.S. Supreme Court denied Coe's final appeal. Robert Glenn Coe was executed by lethal injection on April 19th, 2000. So, finally, she can have the mic again. It took so long.
Wow, what a story.
Yeah.
That's...
Imagine getting lethal injection.
I know, lethal injection is just crazy.
Right here.
Right here. Yeah. Now I'll be talking about some crimes that are eligible for the death penalty on the federal basis. Excuse me. So the case of Coker versus Georgia in 1977 made it so that rape is not eligible for the death penalty. While serving various sentences for murder, rape, kidnapping, and aggravated assault, petitioner escaped from a Georgia prison and, in the course of committing an armed robbery and other offenses, raped an adult woman. He was convicted of rape, armed robbery, and other offenses, and sentenced to death on the rape charge. When the jury found two of the aggravated circumstances present for imposing such a sentence, viz., that the rape was committed, 1, by a person with prior capital felony armed robbery, committed 1 by a person with prior capital felony convictions, and 2, the course of committing another capital felony, armed robbery. The Georgia Supreme Court affirmed both the conviction and sentence. The judgment upholding the death sentence is reversed and the case is remanded. The Eighth Amendment bars not only those punishments that are barbaric, but also those that are excessive in relation to a crime committed, and punishment is excessive and unconstitutional if it, 1, makes no measurable contribution to accepted goals of punishment, and hence is nothing more than a purposeless and needless imposition of pain and suffering, or 2, is grossly out of proportion to severity of the crime. That death is a disproportionate penalty for rape is strongly indicated by the objective evidence of present public judgment as represented by the attitude of state legislatures and sentencing juries concerning the acceptability of such a penalty, it appearing that Georgia is currently the only state authorizing death sentence for rape of an adult woman that is authorized for rape in only 2 other states, but only when a victim is a child, and that in the vast majority, 9 out of 10 of the rape convictions in Georgia since 1973, juries have not imposed the death sentence. So, although rape deserves a very serious punishment, the death penalty is unique for its severity, and it is excessive for a rapist. So, you can thank Coker for that.
That's very interesting, Lyla. Wow. Payne versus Tennessee is a landmark case that reversed prior rulings and allowed victim impact statements to be presented during the penalty. Yes. In Payne versus Tennessee, the U.S. Supreme Court ruled that the Eighth Amendment does not prohibit the use of victim impact evidence during the sentencing phase of capital trial. This evidence, which describes the personal characteristics of the victim and the impact of the crime on their family, can be presented by the prosecution to the jury. The court also held that the Eighth Amendment does not prevent prosecutors from arguing such evidence to the jury. This decision overturned 2 previous cases, Booth v. Maryland and South Carolina v. Gathers, which had limited the use of victim impact statements. So, that's an example of a piece of evidence that is allowed to be used in capital cases.
Wow. What a case. I don't know where we would be without victim impact statements.
I feel like they're important.
I feel like they're very important as well.
I like to hear them on court TV.
I really enjoy watching court TV.
Yeah.
Especially in Miss Harris's first block class. Hold on. He has to stand up. Okay. So you may be wondering, all these people are getting put to death, but how? What evidence is acceptable for them to be put to death? What else? So, in a death penalty sentencing hearing, acceptable evidence includes aggravating and mitigating circumstances. Victim impact statements, like Roslyn said, can have an effect, but they are generally admissible, but the jury must weigh these factors when deciding between a death sentence and a life imprisonment. Some aggravating circumstances that could be considered or used as evidence during a sentencing hearing is a prior criminal record, cruel or heinous nature of the crime, murder or financial gain, and danger to others. So an aggravating circumstance can be one of these things. It is a factor that makes the crime more severe and are presented by the prosecution. Now, mitigating circumstances include mental health issues, youth of the defendant, abuse or neglect in childhood, minor role in the crime, or remorse. These factors are mitigating factors and are often presented by the defense to argue for a lesser sentence. Yes, they could use your school record. So if you're a really good student, that could show that you have been organized and you really care about your future. If they use those in teen court a lot. I use those in teen court. But if you have a really bad record, I feel like if I was the prosecution, I would want to bring up that they haven't cared about their life for a very long time.
Wow, that's crazy.
Quite
Try
crazy.
not to get detention.
Yeah, don't get a lot of detention. So that is our vlog story time podcast project
That we're doing
thing.
third grade.
But we love this class so
I
much.
love this class.
If you're staying to the end, like
Why? Why?
maybe comment what the craziest thing you saw on this table was.
Yeah. What's your favorite thing on this table?
Thank you for watching. Please give us a 100.
Please.